Good morning friends. The applicability of GST on personal guarantees and corporate guarantees provided by related persons to bank or financial institutions have been dealt with under notification 52 of 2023 Central Tax and circular 204 of 2023. We will discuss the various issues with respect to such provisions and the decisions and the impact on trade and industry. So, the decision and the provisions are: in case of personal guarantee provided by directors or other related persons for companies to which they are related, to banks or financial institutions, they would be considered to be as services supplied as per Schedule 1 of the CGST Act, read with Section 7 of the CGST Act. However, as per RBI guidelines and RBI circulars, these related persons or directors cannot charge any commission or consideration or such amount from the companies for such services provided. Therefore, while the provision of personal guarantee to corporates is a supply of services, yet the valuation mechanism fails and therefore no GST is applicable on provision of personal guarantees by related persons to body corporates. However, in case of corporate guarantees provided by holding companies or other related persons to subsidiary companies or other related persons, the same would also be considered to be as supply of services under Schedule 1, read with Section 7 of the CGST Act. The RBI strictures as is applicable to personal guarantees is not applicable in case of corporate guarantees. Therefore, the valuation in this case would be as per Rule 28 of the CGST rules. From 26th October 2023, Rule 28 sub Rule 2 has been inserted, wherein from 26th October 2023, 1% of the value of the guarantee shall be deemed to be the value of the supply of the services of provision of corporate guarantees to banks or financial institutions on behalf of subsidiary or other related entity. Important to note is that it is 1% of the guarantee amount. In many cases, bank charge more of guarantee than the actual value of the loan. Say for example, the loan is of 100 crores, however the value of the guarantee can be 200 crores. For GST purposes, the value of the taxable supplies would be 1% of 200 crores in my example and not 1% of 100 crores. Now, this is from 26th October 2023. What about the period prior to 26th October 2023? Even prior to that, it is clarified that such provision of services of corporate guarantee would be considered to be as a supply of services under GST. The valuation would be under Rule 28, that is the open market value. Question is whether the market value as determined for the purposes of transfer pricing under income tax norms, that is generally the accepted norm is 0.5% of the value of the guarantee. Would that be considered to be as the open market value? The answer is yes, that can be considered as the open market value. However, attention is also invited to second proviso of Rule 28, the erstwhile Rule 28. Now it has been amended and it has become Rule 28 sub Rule 1. So, as per second proviso of this Rule 28 sub Rule 1, the value in such cases where the recipient gets the full input tax credit, the value on the invoices would be considered to be as the value for the purposes of Rule 28 sub Rule 1. So, this needs attention. However, again important to note is that from 26th October 2023, when under GST the value would be 1%, would it impact the transfer pricing norms under income tax? The answer may be a yes, because here when you are raising an invoice for 1%, then it is all the more established that such value may need to be taken for transfer pricing norms also. Again important to note is that second proviso to Rule 28 sub Rule 1 is applicable only in such cases where the recipient gets the full input tax credit. In many cases like alcohol companies, petroleum companies or such other companies which supply exempt or non-GST supplies, the recipient may not get the full input tax credit. In such cases, the second proviso to Rule 28 even for the earlier period may not be applicable. So, valuation for the erstwhile period needs to be determined with care. Another question is when to charge GST or when to charge the value for provision of such deemed services of corporate guarantee to related persons. The answer lies in section 13 of the CGST Act, which provides for time of supply norms for provision of services. Generally, it is seen that corporate guarantees are renewed yearly and therefore possibly a yearly invoice for GST purposes may be required in such cases. Another question is in case of personal guarantees not provided by directors but their relatives, for example director's wife, or provided by non-related parties like erstwhile directors, In such cases, whether GST would be applicable or not, again attention is invited to the strictures as per RBI, and in case of related parties, it is possible that the strictures as per RBI for not charging any consideration would be applicable to relatives of directors also, and therefore no GST would be applicable on such personal guarantees. However, where the RBI strictures are not applicable and in case of non-related persons where there is an exchange of consideration, in such cases GST would be applicable on such consideration. Next question is, in case actual consideration is charged between related or unrelated persons for provision of corporate guarantees, which is actually more than the 1% value as provided under Rule 28 Sub Rule 2, then would it be required to charge GST on only 1% or the higher amount? So here the norm is that GST would be applicable on the higher amount and not 1% deemed value. So friends, there are many other issues which would be typical to the facts and circumstances existing in all companies and in case of all taxpayers. The issue is not that simple. It needs to be analyzed case by case, more in details, and hence decisions need to be taken after analyzing the facts of each case. We hope this video was useful in your professional sphere. Please do like, share and subscribe to this channel. The article related to this video would be available on our website www.taxconnect.co.in. It is also available on our LinkedIn channels. So please, you can go through such articles which analyzes more issues and also provides the legal provisions with respect to such issues. Thank you very much for hearing. Stay tuned.